So independent judicial institutions and commentators have warned that media storms can create pressure and risks to judicial legitimacy. This became even more pronounced after Vusimuzi Cat Matlala's bail appeal was dismissed by the High Court in Johannesburg. That dismissal comes after Matlala was denied bail at the Alexandra Magistrates Court and appealed in the High Court. Matlala is facing charges of attempted murder, conspiracy to commit murder, fraud, and attempting to defeat the end of justice. Let's get a better sense of what to think about insofar as this case is concerned, especially when you consider that these charges fall under Schedule 5. Bringing now NPA spokesperson Phindi Njonondwana, who joins us via our video link. It's great to have you on the program, Phindi. Thanks very much indeed for making time. And I suppose whenever there's a heated debate like we're seeing in this particular case, it's a good idea to go back to first principles. My understanding is that bail is not meant to be a punishment. It's to ensure that an accused ultimately will be able to stand trial. With that in mind, why did the NPA oppose Vusimuzi Cat Matlala's application?
Good morning, Ayanda, and good morning to your viewers. And let me thank you for inviting us as the NPA. Indeed, you are correct. Bail is not a punitive measure. However, it's a measure to guarantee the attendance of the accused person for the trial. So as the NPA, from time to time, we would go to court and oppose bail applications, especially in very serious matters. Our duty as the prosecution is where we have information about an accused person maybe being a flight risk or being of danger to society, or will tamper with the proper administration of justice if released on bail, then as the prosecution would from time to time oppose the release on bail of such people. But however, where we don't have necessarily information to oppose bail, again, as the prosecution would go to court and state that we are not opposing bail. So in this instance, we are opposing bail because we have cited various reasons, amongst them that the accused is facing charges of a serious nature, that there's likelihood that if released on bail, he will intimidate witnesses, he's a danger to society, and therefore he should be kept in custody until he's dealt with in accordance with the law.
Yeah, and of course, because of that, you've welcomed this decision, but we know there have been other instances where other accused who are facing charges that are equally as serious, if not more, were granted bail. And even though you oppose those two, I wonder what the NPA's response to the perceived inconsistency is. Oh, look at that. How's that for timing? It looks like our connection to Phindi Njonondwana dropped us as she was about to respond to that. Hopefully we'll try to reestablish that connection for you. But if you've just joined us, we're having a discussion about the granting of bail in a context where at the level of perception, there's at the very least a feeling that the judicial officers may be swayed by public pressure. This is in the wake of Vusimuzi Cat Matlala being granted bail more recently. There's been some commentators who've come out to say that, in fact, that decision seems more to be influenced by what has been heard in the media than, I suppose, what the law demands at this stage. We're going to try to reestablish that connection to Phindi Njonondwana and continue our discussion in just a moment. Do stay with us.
OUTsurance beat the rest of the market with a premium of just 1,613 Rand a month for Neo's BMW X3. Janine's Picanto is pretty as a picture, and so is her premium, just 561 Rand a month. Helena went round and round trying to find the lowest premium and found it at OUTsurance. Go to outsurance.co.za for a 10-minute quote that could save you thousands.
Do you want to feel protected like royalty, especially when dealing with legal issues? Clientele Legal's nationwide team of professional lawyers stand as your loyal defenders, protecting you in civil, criminal, and labor-related matters. Clientele Legal is always ready to protect your legal rights. We provide superior legal services for an affordable monthly premium. Clientele Legal will always protect you and your family. Our dedicated legal team are standing by 24 hours a day, ensuring your peace of mind.
Clientele Legal gives me peace of mind.
Clientele Legal are professionals and they can help you with any legal matter.
Clientele is the best.
Clientele Royalty is your free loyalty program offering a wide range of monthly savings and discounts. Spin for a chance to win your share of 10 million rands in prizes with Spin and Win. Clientele Royalty, rewarding loyalty. SMS LEGAL to 48523 and we'll call you back. SMS now.
Welcome back and thanks for staying with us. Let's continue with our discussion with NPA spokesperson Phindi Njonondwana, who joins us via our video link as we try to, I suppose, distill through the noise in the wake of this public debate about whether or not the courts were fair in denying Vusimuzi Cat Matlala bail. Phindi Njonondwana joins us once again via our video link. Apologies for that, Phindi. It seems we lost you as you're still trying to respond to my second question at the very least. I mean, you have done a good job at explaining to us instances when the NPA would deny or rather oppose one's bail application. But we've seen similar cases, for example, where an accused is facing a very serious crime but was granted bail. At the very least, for people watching from the outside, there seems to be an inconsistency on that front. Help us, I suppose, think through the NPA's response to that perceived inconsistency at the very least.
Okay, first of all, the public must understand that the decisions to grant or deny accused persons bail, they lie with the various presiding officers. So ours is to furnish the court with the necessary information for it to arrive at an informed decision on whether or not an accused person is a proper candidate to be released on bail. So the decision itself lies with the court.
Perhaps let me ask the question differently then. Does the NPA feel that there are enough safeguards to ensure that that decision is consistent at the very least?
Indeed, yes. We are confident that there are necessary safeguards. As you would recall in this Matlala and the KT Molefe bail applications, once they were denied bail by the lower court, they then approached the High Court. So that is part of the recourse mechanisms that are available. However, they also stretch to us as the state to say when we are dissatisfied with a court's decision to release someone on bail and where we have proper grounds to take that decision on review, then we will also bring an application for such an appeal. For instance, in the case against the 12 members of the South African National Defence Force, as the state, we've also brought, we approached the High Court of Johannesburg to review the decision of the lower court of Randburg to grant them bail. So we are still awaiting the date of hearing. It's somewhere late in November where such an application will be heard. So it's sort of a balanced system for both accused persons and the state, because you'll recall under that in terms of the Constitution, everyone has a right to freedom. However, that right is not absolute, which is why when a person is facing charges of a serious nature, they are arrested and they cannot be provided bail at the police station. They have to appear formally before court, bring a formal bail application. And the honors to be released on bail also lies with the accused person. They are the ones who are supposed to convince the court, especially in Schedule 5 and Schedule 6 offences. The onus is with them to convince the court that they are indeed suitable candidates to be released on bail. And then us as the NPA, from time to time, we will oppose such an application. It's only in Schedule 1 offences where the onus lies with the state.
I can't remember a time where there was so much attention on these legal processes. And I wonder, Phindi, in your own career, whether you agree with me or not. But to what extent does that complicate your work as the state in these kind of proceedings? The fact that there are so many cameras, quite literally, but also so many interests, it seems, to try and negotiate.
Well, these kind of proceedings are complex in their nature. However, as the state, we rely on the expertise and the experience of our prosecutors to challenge these matters with the understanding that society relies on us as the NPA as well as our courts for protection. And therefore, it is incumbent on us as the state to provide such protection by going to court in instances where an accused person is arrested for charges that are of a serious nature, to go and challenge the release of such an accused person. But as I've indicated, that decision at the end of the day lies with the court.
Yeah, fair enough. There have obviously been long-standing arguments about how, tightening bail conditions may ease public frustration, but there's also, I suppose, the flip side of that discussion around how it may lead to more overcrowding. Beyond the issues you've just outlined to us, is that a consideration that the NPA makes in these proceedings?
Well, we must understand that in making their decisions, the court as well seeks to balance the interest of justice, the interest of society, as well as the interest of the accused persons. However, we are, as the NPA, continuing to empower our prosecutors through various prosecutorial strategies and trainings, because we understand the need for society to be protected. And whether or not we have overcrowded prisons, that cannot be a reason for people who are accused of committing serious offences not to remain in custody until they are in accordance with the law.
All right, fair enough. Phindi Njonondwana, thanks very much indeed for speaking to us. As you can see, these are stories we're watching very closely, and I have no doubt one of our reporters will catch up with you outside one of these courtrooms in the next couple of days. Phindi, once again, is the spokesperson for the National Prosecuting Authority. Thanks very much indeed. We're hoping to also catch up, by the way, with someone who's been very vocal about the bail application, or the bail outcome, I should say, involving Vusimuzi Cat Matlala. As soon as they're ready, we'll try bring that discussion to you to get you a sense, at the very least, of what some people have to say. All right, I'm told Tumelo is, in fact, ready. He's an attorney, Tumelo Vana, and as I mentioned, has spoken out against the outcome of the bail appeal process involving Vusimuzi Cat Matlala. Tumelo, I'm hoping you're able to hear us. Welcome to the SABC News Channel. Thanks very much indeed for your time. The NPA has come out to say, I think, what many people like you would probably know, right? They oppose bail in instances where they feel that the person who is accused being granted bail would not be in the interest of justice. You, however, feel very differently about the outcome involving Vusimuzi Cat Matlala. Let me start by asking you why.
Good morning, sir. I hope you're doing well. The issue here is that they feel, we're talking about feelings, and we're talking about there's a law and there's a feeling, right? So my view is that bail must be guided by evidence, not speculation. So the law doesn't punish before trial, it manages risk. The purpose of bail is to manage risk, not how we really feel. You understand? So the law is very clear. So under Section 60 of the Criminal Procedure Act, bail depends on whether the interest of justice allow release. Even on serious cases under Schedule 5, bail is not automatically refused. The state must prove that no conditions can address the risk.
Yeah, but the concept of managing risk, I'm sure you'll agree, is also a bit elusive. In this particular case, I imagine the court would have had to try balance the right to someone's liberty and not to be punitive, but also consider the very serious, let's call them allegations of interference that we've had or heard involving this accused.
I agree, but now we're talking about allegations. So when you make allegations against a party that such a person has committed a certain act, but now when you're gonna take away a person's liberty, right? So for you to take away the person's liberty with accusations that has not been proven, the court has to balance the two. When you're going to take away a person's liberty, you should not just come with allegations. You should be able to come with concrete evidence that the court should be satisfied. I mean, we're dealing away with taking a person's liberty here. That is a limitation clause in the Constitution. So we're not taking away a person's right. We should have certainty that there are high possibilities that the person will be convicted. But in this case, we are not sure because of all that the state comes with is allegations. None has been proven to be certain to give the court confidence that indeed the person is a flight risk. Indeed, the person will tamper with witnesses. All those things are just mere allegations. And for coming with allegations, then tamper with a person's right, I don't think that's fair.
So what? You're saying the state not only brought weak evidence, but the court made their decision of weak evidence. Is that correct?
That's what I'm saying. But again, I think the courts are under pressure now. You know, they're trying to please society. They're under pressure of, and at that, you know, being under pressure as it is, it's at the same time losing their independence. Because of now, there are many allegations against courts being biased, so now they are falling down to the pressures of society. And at the same time, they're putting the accused to prove their innocence instead of the state proving the guilt beyond a reasonable doubt. Now is the accused who has to prove his innocence in order to be free. If the state is going to allege that the person is a flight risk based on just affidavits, non-affidavit statements without coming with concrete evidence, then the court is going to risk taking away a person's liberty based on just mere allegation. Is that fair? Then it's a risk for all of us. You know, any person now is going to be accused of something, because this is a high court decision, and the high court, most of the high court decisions set precedents. So it's going to set a bad precedent now, because of now a person is going to now prove they are innocent beyond a reasonable doubt, instead of the state proving the guilt of an accused.
I suppose for you, where the rubber hits the road is around the quality of the evidence that was brought forward. My understanding is that the state did manage to prove that Vusimuzi Cat Matlala has substantial resources, and I suppose you could infer from that you can pull your resources to skip the country if ever you needed to. But they were able to find that there were offshore assets, including foreign bank accounts, the possibility of a fraudulent ID that was used in Eswatini. You know, again, I'm no lawyer, but if somebody were to present that kind of evidence before me, I would wonder whether or not this is an ability in some instance to be able to skip the country, to abscond.
So now we're not supposed to have wealth. Now it's becoming a problem now. So just because of one has resources, they're automatically a flight risk. The allegation about fraudulent passport is serious. I'm not saying it's not serious, but seriousness alone does not prove flight risk. The key evidence that the state show recent or planned use of the document to evade court. If not, it remains an untested claim. Yes, he reportedly traveled to Swaziland, but he also returned. That shows compliance, not evasion. Travel before arrest doesn't equal flight risk, especially when strict bail conditions can control movement.
All right,
so having money or connections outside the republic doesn't make one a fugitive. It becomes relevant only if the state can show current plans or means to abscond. Courts need proof of intention, not assumptions.
The good news, of course, is that this is not where the story ends. Both the NPA and Vusimuzi Cat Matlala have recourse if they don't feel that the outcome has been fair. And I suppose you and I will have to watch very closely as we continue learning about what the law actually demands in either of these scenarios. Tumelo, let me thank you for your time. Appreciate it. Tumelo is an attorney speaking to us there in the wake of Vusimuzi Cat Matlala's bail outcome.